wrote a wills and trust issue spotting checklist once upon a time, and there are a lot of pages to it. So it's not gonna get recorded probably all at once unless I can make great haste through it. And I can't say I'm entirely sure what it even contains because it looks like a case list. So we're just going to start with a present transfer test. And the substantive law that I have along with that issue is that fundamental principles of trust require present conveyance of the beneficiary's interest. Fundamental principles of trust require present conveyance of the probably beneficial interest, not beneficiaries, but I'll say settlers' interest, and the existence of a present enforceable duties, and it would permit the suspension of the beneficial ownership, a notion repugnant to the requirements of a trust. Present transfer test is one of the requirements for creation of a trust, and a name change in the property title is often required. So that's comes from UTC, Uniform Trust Code, Section 401. Inter vivos trust requires present, future, vested, contingent interest in property and lacks the same formalities as a testamentary trust in which property passes after death. Formality: exhibit in trust showing assets moved to trust. As the settlor of the trust, I am hereby depositing the assets attached to exhibit to the trust corpus, for example, furniture, furnishings, all my personal property, jewelry. If there is an ownership document, then change the name of the owner to the trust stocks, change name with corporation for reissue in name of trust, and a pour over will is a companion document in every revocable trust. Everything I have failed to deposit into my trust during my lifetime, I pour over or grant to the name of my trust. So I'm giving these citations because that's actual language that you would use in the instrument that the book probably gave us. It also, like I said, comes from the Uniform Trust Code, certain parts of this, certainly about the present transfer test. And then there's a family law citation, Uniform Probate Code. It looks like subsection 6 that is being discussed in here. But within this section, like I said, this is a weird sort of an outline where I think I crammed like everything I know about that topic into that section. And then if there's a case that I have about it or a case holding, I put it here. So there isn't one for present transfer test. Let's move to the next one where there are some cases. Farkas versus Williams, setting forth the inter vivos trust requirements, and Spicer versus Wright and Levin v. Fish for intent to create trust. So, this is the formalities. This is this has to do with the present transfer. Now we're talking about the characteristics of an express inter vivos trust. Obviously, like I just stated, the trust requirements and intent. Learned a couple things from Barbary, like for instance, if a trust does not include land, it doesn't actually have to be in writing. You do need that transfer of title if there is any, but it doesn't require a writing unless the trust is to contain land. But you need to know what the trust requirements are. And like who's the trustee, who's the beneficiaries. So how you would get that across. Some of these are, quote, self-settled, which means that this language that I said, as the settler of the trust, I'm hereby depositing and making a transfer to the trust, that can essentially be all that's needed to create a trust. So you transfer the trust, and he's going to act as the trustee until later on. But that's enough about that. The definition: a trust is a fiduciary relationship with respect to property in which the trustee holds the legal title to the trust property, the res, subject to enforceable equitable rights in another, the beneficiary. It is a device whereby one or more persons manage the property for the benefit of others, requires valid trust purpose. So fiduciary relationship with respect to res in which the trustee holds legal title for another. And that's probably the end of the definition. Then it says, it is a device whereby one or more persons manage the property for the benefit of others. Valid trust requires a valid trust purpose. The trustee has legal title of the property. Talked about the transfer kind of requirement already. Beneficiary has equitable title. The testator grantor who creates the trust and express trust is the settler who must have intent to create the trust. So it requires intent. Those are kind of the major components, is the legal title and the intent. Obviously to create a trust, but to make a transfer and for the benefit of the beneficiaries. They can be pets or plants, which I'm writing in the margin here. That's an honorary trust. Indefinite class is valid, like to my grandchildren, because extrinsic evidence can define that class, or can be used outside of the trust to define that class. What did I just say? What's not required? Consideration is not required for the creation of the trust. Rather, trusts are created gratuitously, gift, not a bargain for exchange. Element 1, a competent settler with the capacity to create a trust by words or action. Present intent to take immediate effect, verified by the present transfer test, and trust property, a lawful purpose, and the trust bending, which can be the settler or the trustee, but requires the contingent beneficiary with the future interest, either life, estate, or remainder man in a declared trust. I'm defining that as like 5 elements. I mean, that's going to probably be the hardest of this, or at least the most important of what you have to really memorize in order to survive the exam. Capacity is further defined by the Restatement Third of Trusts. What testamentary capacity does the settler need to create a trust? 1, 2, and 3, a person has capacity to create a trust by will to the same extent that the person has capacity to devise or bequeath the property free of trust. 2, the person has capacity to create an irrevocable inter vivos trust by transfer to another or by declaration to the same extent that the person has capacity to create trust by will. And a person, third, has capacity to create an irrevocable trust by transfer to another or by declaration to the same extent that the person has capacity to transfer the property free of trust in similar circumstances. I'm not highlighting any of that because Barbara gives a much better definition of capacity. This we'll move on to undue influence, duress, and fraud, which would affect your capacity calculus. A trust is void to the extent that its creation was induced by undue influence, fraud, or duress. From Restatement Third Trust, Section 12, which is the following section after the section I just read. So this is actually like the restatement definition of capacity. It's a shame because I can't remember that. And so we're gonna go with Barbie's definition. Which I wonder if we should just do that now, because I mean we're 30 days from the exam. We don't have time for all of this. Go get. So I don't actually have it for trusts, but I do have it for wills. What's testamentary capacity for writing a will is that you need to know the extent of like the bounds of your property to be transferred. You need to know the objects of your bounty, which are the people to receive it. And you need an awareness of the like nature of what you're doing. I'm just gonna write awareness there, but you need to know that you're writing a trust. Looking to see if I've got any other definitions of testamentary capacity. Not really. Yeah. So that's gonna have to do it. I know I missed something there because, you know, maybe I wrote it down here. I don't believe I did because I didn't start writing notes in here until much later. So we'll just hang on to that idea. Undue influence, fraud, duress. I just spoke on the next section, which I don't hate that definition. It just kind of is a good way to introduce the fact that probably the next thing you're going to talk about is what is undue influence, duress, or fraud in your exam. Trust is void to the extent that's created by induced by undue influence, duress, or fraud. Creditor may take to satisfy indebtedness if trust was created with purpose to defraud, and the surviving spouse may take by elective share where applicable. So these are notes from the Farkas case too. Elective share is, we're not getting into that right this instant. Just because it's such a mix between community property and trust and wills. To say it succinctly, elective trust the operation of elective trust arises in the surviving spouse who did not receive their the share of community or separate property that ought to have been transferred them according to probably the state's laws. And by electing, they are going to like contest gifts made to others to call them back to the surviving spouse because they exceeded the amounts that public policy would expect surviving spouse to receive. Now, the other thing here about creditors, taking if the purpose was to defraud. So a type of trust that I haven't gotten into yet, I don't know if we're getting into types of trust here, is a spendthrift trust. And so most every trust, spendthrift, contains spendthrift language that would protect the trust property from attachment by creditors of either the beneficiaries or the settlor. And it kind of depends on the settlor. If it's irrevocable, then most states will give effect that. If it's a revocable trust, some states don't allow or don't give effect to spendthrift trust language that seeks to prevent, I'm just going to write prevent creditor attachment to trust property. But there is a big movement to just having these clauses and language be valid. Yeah. And so I'm going to move on to the merger doctrine. Trust terminates when the legal and equitable title are both in the beneficiary. So there's like 1,000 hypotheticals that I got every single one of them wrong in Barbary. And they went to the effect of settlor appoints like Amy and Bobby to be the trustees for Amy as the beneficiary. And is that sufficient, like, division between the legal title and the equitable title? And the answer is yes, because Amy and Bobby are managing for Amy's benefit. Likewise, if Amy's a trustee and Amy and Bobby are the beneficiaries, that's a sufficient division between legal and equitable title. And in fact, I think they said that Amy and Bobby as trustees managing for Amy and Bobby's benefit is sufficient division of legal and equitable title. The trust is going to terminate if it's like trustee Amy for trustee's benefit, or trustee Bobby for Bobby's benefit. So just look for that. The case on that is Matthias versus Fantine. My holding here is that for early views of the merger doctrine's effect on revocable trusts, however, the courts distance themselves from that case holding in 1990. Restatement third of trust. Trust destroyed if the legal title to trust property and the entire beneficial interest become united in one person. So that's just another way of saying it. My page numbers barely. So we're on page 3. Substantive requirements of a trust. Here's your section from Hagstad case that sets forth that there needs to be a certainty of subject, a certainty of object, a certainty of intent, a certainty of trustee. So those 4 are broken down: subject, object, intent, and trustee. In subject, a trust cannot exist without a res, except for Hagstad, which had a Hagstad exception if a QC deed, probably quitclaim deed, was not executed, but the self-declared trust indicates in the trust that he is transferring his own property into the trust. That would be sufficient. Certainty of object, identifiable beneficiaries, for example, must be definite and identifiable. Friends is too broad. So you say grandchildren, those people are ascertainable, but friends is unascertainable, even if you were to say friends as identified by my trustee, I think. Now, certainty of intent, on the other hand, precatory language, wishes, creates an inference but not an obligation, an imposition of legal duty or moral obligation on the legatee. And in California, the test was to look at all surrounding circumstances. It is my hope that she will use part of this money to support my mother and sister. Oh, that was an early case. Excuse me. Factors: decedent wrote the testamentary trust in a hurry. The decedent provided support for the family throughout the life. And those are the factors that went into kind of interpreting what's the intent of the testator. In property law, intent, delivery, and acceptance, which is presumed in trust law as it is in other areas of law. So I'm just going to leave it there. I don't know the case name for that precisely, but it's like a seminal 1800s case. Certainty of trustee. Position of duty must be established, but the identity of the trustee will not defeat the trust because the court can always appoint a trustee. However, the individual's trust needs position of trustee and settlor to be named or himself so as to transfer trust property to trustee. They have duties. There may be multiple trustees that exercise powers together unless authorized differently. Statute governs charitable trust of greater than 3 trustees to act by majority rules. Multiple trustees follow majority rules. Okay, so the trustee must have duties. That's interesting. I highlighted that. Settlor can name himself. All right, trust does not fail for a lack of trustee. Like they keep saying this, but it comes from Adams versus Adams in 1874, who gave a deed of trust to the wife with trustee Appleton to manage property for interest of wife during her life as she may direct. He denied holding that position when husband and wife divorced and he seeks to rent their Washington D.C. estate, because this Adams was a political figure. And so they seek to rent the property after prevailing on alimony issue. And the court witnessed the deed of trust, used it in the alimony decision, and ruled that the trust does not fail for lack of trustee acceptance. So they're trying to pull a fast one, and it didn't work out. And the ruling in this case is that a trust does not fail for a lack of a trustee. Trust does not fail because no trustee is designated, because a designated trustee declines, is unable, or ceases to act unless the trust creation or continuation depends on a specific person serving as trustee. A proper court will appoint a trustee as necessary and appropriate. General powers and default rules. So I'm just going to arrow down to my section that says a trustee must have duties. And to this section here, rules designated to implement the likely wishes of most settlers and that yield to expressions contrary intention. Okay, and loyalty, prudence, and Uniform Prudent Investors Act. And posting a bond sometimes is something that they expect of the trustee. So those are 3 examples of things. And moving on to the Uniform Trust Code, Section 105 clarifies which duties are default and which are mandatory. I like using that language, default and mandatory, by explaining which fiduciary rules cannot be overridden in a trust instrument. So that's kind of the difference between the 2, default rules and mandatory. Some of them cannot be overridden. I don't know which, but we're going to read what mandatory powers are. It's a subgroup of default rules. And requirement that the trust and its terms are the beneficiary's benefit. So that's probably not able to be overridden, but I'm not sure. And Section 105B2 says to act in good faith and in accord with the terms and purpose of the trust and interests of the Benny. So I think that's what's mandatory. What's the mandatory rules is like good faith and accord with terms for the beneficiary's interests. I think those are probably mandatory and cannot be like waived by the language used in the trust instrument. And there's the house plant trust, non-charitable purpose trust without an ascertainable Benny. So it's honorary. I made sure to remember the name of that. So I can write it here. And it comes from Uniform Trust Code Section 409. And what Barbara said is that every single state has laws on how to set up an honorary trust. Remedial trusts, resulting trusts, which is, for example, a reversionary interest when a home buyer puts down payment money aside for a homeowner who has equitable title in escrow containing down payment purchase money, and the bank has legal title. It terminates by merger doctrine, and constructive trust is an equitable remedy to prevent unjust enrichment. So I'm just going to highlight the words. Resulting trust and constructive trust. The example of a resulting trust isn't great. In constructive trust, you can lean on what the definition is in remedies, which I have right here. Reconvey wrongfully acquired property. Plaintiff directly traceable to title of new defendant's new property, right? So it requires tracing of property wrongfully taken from the plaintiff and creates like an abstract trust for the benefit of reconveying the wrongfully acquired property back to the plaintiff. So in such an example, the defendant actually can be the trustee, and that's an example of a constructive trust. I'm not going any more examples because I'm on page 5 and I've got 50 pages. So really 1/10 of the way through this. Res, a trust cannot exist without a res except for Hagstadt exception, like we were talking about. Any property type, including future interest, the settlor has a right to convey. Any type of property may be held in trust so long as the trustee has the ability to transfer it. For standards of statute of frauds, a writing is required to transfer trust res to the trust. Personal property may be transferred by including it in the trust in sufficient detail to be able to distinguish it. Statutory formalities. Inter vivos trust does not require writing. I was just saying some states require writing for land. Illinois, New York, West Virginia, North Carolina. For statute of frauds, a writing is required to transfer res to the trust. Personalty trusts need no writing and may be proven by clear and convincing standard. So it might be good to know that, right? Restatement second of trust, section 43 at 112, where an oral trust of an interest in land is created inter vivos, the trustee can properly perform the trust if he has not transferred the interest, although he cannot be compelled to do so. Parole express trust. Goodman versus Goodman sets forth the trust formalities. Okay. Testamentary trusts require a writing, however, and they arise within the will if properly executed. In the example I gave before, same language, I hereby establish a trust, and it says go through probate for court to establish the trust. I hereby establish a trust. It shall consist of all funds in the bank account until daughter with 18 years old and Uncle Joe should marry and her for her benefit. I don't know. It's example language. Secret and semi-secret trust. A gift is given but is meant to be a trust. The trustee or beneficiary must come forward with the extrinsic evidence showing that the property was not given outright to the trustee, but in trust for another. Benny, semi-secret trust is a gift, but the Benny is not named, not valid unless there is proof of who is the intended beneficiary. The case on point here is Olive versus Wells regarding a secret will. The legal title without a beneficial interest in will cannot defeat legal heirs' interests, contrary to English law, allowing it in Blackwell versus Blackwell of 1930, giving, I think, £12,000 for mistress and son. Revoking or amending a revocable trust. Majority considers lost trust to only be revoked if trust is revocable and revoked by available means. Minority considers the method of revocation must be exercised if given, if not requires definitive manifestation. Estate and trust of PLFS is kind of the citation for this. The settler who also serves as trustee can amend the trust by writing an amendment letter to himself, notarizing the letter, and delivering it to himself, which we know this is the self-settled trust, but it's an amendment. So that's the way that an amendment may be executed. There's some case law here from the Restatement Second of Trusts, Section 330, Third of Property, Uniform Trust Code 602, Revocation of a Trust, English case law by Saunders versus Bellier. Not a majority for 50 years was an earlier application of termination upon age of majority in absolute indefeasible interest in the thing defined and certain, because equitable interest not subject to restraint of alienation. The principle followed in the U.S. until 1889. Shaflin was from 1889. Wow. Well, now you can spell the name of that case right, because in Shaflin versus Shaflin, Massachusetts, 1889, death of settler, and Shaflin is age of majority, but not age prescribed under trust to receive benefit. Trust is vested, and Shaflin moves for court to compel trustee to distribute, but the following traditional English law requirements applied: trust not dry, and purpose is to disperse as trustee stipulates, and there is no good policy reason or property right reason not to see through settler's intent. So the Claflin doctrine is that all beneficiaries, ascertained, unascertained, and unborn, can be represented by a guardian ad litem, must consent to the modification, and the modification cannot affect the material purpose of the trust. And I got like semicolon more stuff here, a lot more stuff here. So living settler may revoke an inter vivos trust by showing intent in a way allowed pursuant to terms of the trust, a writing signed and notarized by the settler and provided to the trustee, or by a post-dated will if the trust allows for this form of revocation. If irrevocable, the settler is alive and beneficiaries must consent, even though the termination will interfere with the material purpose by way of settler enjoining in trust revocation, restatement second of trust, section 337, beneficiaries of trust cannot compel the trust premature termination or modification unless, this is probably the better part to have highlighted, is all beneficiaries consent and are competent to consent. Termination doesn't defeat the trust material purpose or without settler consent in irrevocable trust on this point, and or settler with settler consent in revocable trust on this point. So I feel like this is the Claflin doctrine sort of elements. If you're going to use them in an essay. Footnote, material purpose at traditional law. So what's the material purpose of the trust? Indestructible trusts have material purpose that precludes premature termination, postponement of enjoyment. For example, settler grants principal and interest until specified age, time lapse, or specified date. And I wrote STT is indestructible, so it says spendthrift trust is indestructible. Texas and California diverge from the indestructible absolute. And support and discretionary trusts are indestructible. So there's 3 potential examples of material purpose. There's postponement of enjoyment, spendthrift trust, and support and discretionary trusts. Right? So 1, 2, and 3. There you go. Restatement third of trust, section 65, comment F, material purpose and modification. Although a trust may have a material purpose that would be preclusive of complete or even partial termination of the trust, a particular modification agreed to by the beneficiaries might not be inconsistent with any material purpose of the trust. For example, modification procedure for changing the trustee, highly scrutinized in comparison to trust provisions. Relaxation of material purpose term outweighs benefit of material purpose not readily to be inferred. For example, what was settler's objective for balancing approach? So if the trust can't be dispersed for 80 years and you got kids that are at the time infant, and now I have to wait till they're 80, that's too long. Does that outweigh the material purpose? Yeah, you want to postpone enjoyment, but how are you going to really enjoy it if you're 80? And I mean, you can, but I'm just saying, you might not live to be 81 or something. So states diverge. Washington doesn't follow. Alabama doesn't, or Alabama allows termination if amount managed is uneconomical. So that's probably too little for it to be worthwhile to manage. Trust protector can be given power to terminate, prematurely modify, replace the trustee, or control trustee actions. I don't know about this term. I don't remember writing, but whatever. Beneficiary consent to modify, still in the same sort of general area of this. It affects the Uniform Probate Code, section 2-707 involves beneficiaries that can consent to terminate the trust. And restatement third on point, because I just combine all of the different citations and cases on this particular topic of the beneficiary's consent to modify. So all that the Uniform Probate Code is saying that beneficiaries can consent to terminate the trust. That's the effect of the Uniform Probate Code. But from another source, Restatement Third of Trust, Section 65, Comment C, I'll say, rather than say involves, I'll say applies when the beneficiaries aren't unified in consent to terminate. So consent on behalf of minors and incapacitated persons Others cannot compel termination, but conservator guardian may consent for incapacitated beneficiary in some jurisdictions. Probably not California because everyone in my class disagrees that this is okay. And I'm like, it is okay, but that's just because I read the book and it does cover more than just California. So that explains that. Consent on behalf of unborn or unascertained persons may be represented by guardian ad litem, may be represented by doctrine of virtual representation. This is when it applies. I don't actually think it applies. I keep pointing to Chafflin, but what I should be pointing at is the restatement third of trusts, not adhered to in every state of the United States. In a case, Hatch versus Riggs National Bank of 1966, talking about either the guardian ad litem or the doctrine of virtual representation. For the doctrine of virtual representation, the unborn or unascertained persons are held to have been represented by a living party to a suit if the latter have the same or similar interests as those of the later born or later ascertained beneficiaries, and if the respective classes of interest are not otherwise adverse to another. This is also supported in the Uniform Trust Code Section 304 and the Uniform Probate Code Section 1-403. Relaxation of the unanimity served by a proposed term or modification if continuation of the trust is not acquired by material purpose requirement. So you're going to relax the unanimity if it's served by a proposed term or modification, and if the continuation of the trust is not acquired by material purpose requirement. I wrote acquired. I don't think that, acquired. And if the continuation of the trust is not required. Probably required. That's what I'm trying to say. All right, so in a manner not essential to the interest of the non-consenting beneficiaries, which is probably like your later borns. And restatement third of trust, section 339, settlers' right as sole bene to terminate, restrain on alienation, and indiscretion are considered. Pretermitted heir, also called omitted heir, to let pass without notice is pretermitted. What's the other thing? When a trust is formed before a child born or child left out, or when the settler didn't know he had an heir and raises the presumption that the child was omitted, not intended to be left out of the estate plan, an heir is left out of a will or trust. The afterborn child or child unknown to be living to the settler may take his intestate share which will be accomplished by the process of abatement. In order to produce the intestate share, the court will reduce proportionally abate the other children's shares in order to generate enough funds so that the pretermitted heir can have his or her intestate share. The only time the child may not take is if the instrument expressly disinherits them. If no children are named, then the pretermitted heir. If the other children get more than intestate, then he will share equally with the other children in some states. But that's not everywhere. So California, they like to give the pretermitted heir a kind of an interest. intestate share. Exceptions. Then born children were devised above if the state goes to surviving spouse who is the parent of the preterminate heir. The assumption is that the surviving spouse parent will provide for the child. Uniform Probate Code Section 2-302. What I wrote is former a child not named or provided for in the testator's will takes his or her intestate share. Most jurisdictions protect after-born children rather than any omitted heirs. And then I don't know the current, but I've written that the exception is Louisiana follows civil law. Civil law nations like Rome and legitimy, which doesn't allow for children to be disinherited. So, just for curiosity's sake, did I spell legitimate wrong, or is legitimy some type of a Roman word? So when I look it up, all I get is a bunch of Italian. So it's saying civil law of Louisiana, the portion as 1/4 of a testate succession that is reserved for a forced heir, called also forced portion compared disposable portion. And then they use some crazy word, and I can't figure out where. In French, from Latin, legitima, pars, and lawful share. So this is interesting. Forced portion. Well, isn't that interesting? Okay, and keep going. Spousal support family allowance. Family home is retained free of the attachment of creditors up to an amount certain for the life of the surviving spouse. Statutory support of family and children, and court may sustain the mode of living while probate is pending. So I'm unsure if this is referring to trusts or if it is referring to an actual family allowance, which is a thing that states provide for, or if they're talking about like a support trust. I can't really tell from this. So I'm going to move on to spendthrift trusts. This is has a lot of history going back to England. I've got 3 cases here on it. I guess I'll go with the cases first. In Broadway National Bank versus Adams, this is a seminal case wherein the trustee may alienate the trust assets of spendthrift trust. It consists of dictum from Nichols versus Eaton from 1875, favoring the spendthrift trust, but voids disabling restraint on equitable life estates, not forfeiture restraints. So this is like, those 2 things are very much part of the definition of restraints on alienation. I wish I knew the definition of them, but it's not relevant for this. I mean, it is, but not sure how. So Adams revered by Estate of Vaught. And okay, so probably reversed Estate of Vaught and revised so the Spendthrift Trust restraints on P were valid. And in Estate of Vaught, on 4 occasions, the Benny assigned interest in anticipated payments from trust based on actuary tables at the deep discount to support his drinking habits, and the Benny died before the vesting. The creditor's claims were invalid. For example, New York court and probably appeal court gave effect to the Spendthrift Trust provision in 1969. And what we're saying is like, give me a loan for what I'm going to get from this trust. And you do that once, you like won't give me the full amount, but then you'll give me, the next time I come, you'll give me like a lesser part than before. And the actuary tables just kept being like, so like, it was like probably like pennies on the dollar is like how much I could borrow against my expected future interest. And then I died from alcoholism. So they come out after the trust to be paid, and trust spendthrift provisions prohibit them from capturing or from claiming that beneficiary's interest in trust because of 2 things. One, there's a spendthrift provision, but also because they assume that risk, and we're in a position to do that. A spendthrift trust is a trust that contains a provision imposing a disabling restraint on an alienation on the beneficiary's equitable interests. A disabling restriction on alienation is one that purports to nullify an attempted assignment by the beneficiary of one of his economic interests and any attempted attachment of the beneficiary's interests by the beneficiary's creditors. Example, going back to the actuarial tables to give the present value of the beneficiary for life, how long they'll live when these or how long maybe the settler will live or whatever. If the trust is dispersing on someone's death, they'll do like an actuarial table as to like when that person's expected to pass, and then they will do the present value based on that as to what they'll actually offer you in a loan against your equitable interest in the trust. American SJC case decisions are responsible for strengthening the spendthrift trust provisions and trustee control power to enforce donors' wishes, not beneficiary. Restatement second of trust, section 154. Support trusts have spendthrift protection from creditors, not transferable by the Benny or attachable by creditors, not dependent on the use of any particular form of words of the terms of trust, and thus restatement third abandons distinction and gives consistent treatment in section 60. I still don't have a really good definition for support trust. So let's actually affirm that I didn't cite that actual law. Okay, maybe I did. So that's the actual law, I think. So I'm giving real citations now. Uniform Trust Code, section 504, single rule for discretionary trust. To be valid, both must prevent both voluntary assignments and involuntary assignments, restrain on nation which prevents, per section 60 of restatement, any liability on the trustee to disregard a third party creditor claim to trust principal and interest except child support, spousal alimony. But case law states, or common law states, finding a breach of trustee's fiduciary duty, allow for finding a breach of fiduciary duty. requires boilerplate language. So the Spendthrift Trust does require this boilerplate language. I don't know if, here's an example. Contained routinely in trust, no interest of any beneficiary in the income of a or the principal of this trust shall be assignable in anticipation of payment or be liable in any way for the beneficiary's debts or obligation and shall not be subject to attachment. The beneficiary may give away, assign, transfer his interest, or allow creditors right of attachment until it is distributed. Restriction on alienation cannot apply when a settlor is a beneficiary. Exceptions: child support, spousal support, government taxes, tort judgment credits. Creditor result from tort or criminal act or beneficiary is settlor or claim is brought during grantor's life. That comes from the restatement third of property, section 72, comment B. And I wonder if I've got the case on that where this like drunk idiot just like runs people over and then has to pay for it, notwithstanding the Spendthrift Trust. I don't actually have that one. I think I read the estate of did I read Wilcox versus Gentry? The trustee liable to creditor claim for fraudulent real property transfer. The spendthrift provision restraint on alienation not applicable. If trustee knew about creditor's claim, he therefore could not use discretion to forego payments to Isabel in an attempt to avoid garnishment by her creditors. So that one is a really difficult case. I think that's what like the whole case book started with. Oh no, it's case number 50, but still. Before I jump down to the bankruptcy code, let me look at some of these other case citations. It is permissible to demand property outright and free of trust. Talking about indestructible spendthrift trusts from restatement second of trusts, comment I, section 152, 53 through 30, exception. Uniform Trust Code, section 505, again, creditor's claim against settlor, credit of settlor may attach her into or at least contributions if greater than one settlor. Uniform Trust Code, section 503, 504, 814, discuss support, discretionary support trusts. It'd be good to go get the definition of support trust from there. Support trust is a trust that contains a provision directing the trustee to pay as much of the income and principal as is necessary for the beneficiary's education and support. The beneficiary's interest is not reachable by creditors to the extent necessary to support the support purpose of the trust. Okay, so trust that contains provision directing trustee to pay to the Benny as much of the income and principal as is necessary for the Benny's education and support. The Benny's interest is unreachable by creditors of who? It doesn't say whose creditors, like if it's the settlor's creditors, if he's still alive, or if it's the Benny's creditors. To the extent necessary to support purpose of trust. So you've got like several $1 million in there, and education and support is like, even for 4 years, even for 8 years, let's say this person wants to be a doctor, is at best going to cost $1 million, and maybe the other couple million can actually be attached by creditors. Where are we? Look at the next page. We're talking about bankruptcy code, so I guess that's where your creditors are. Property of the estate does not include any power that the debtor may exercise solely for the benefit of an entity other than the debtor. So basically, in other words, the bankruptcy court recognizes spendthrift trust as a restraint on the transfer of the beneficial interest of the debtor in a trust that is enforceable under applicable non-bankruptcy law is enforceable in the case under this title. A restraint, it's enforceable. That's what that means. Special language. So I like how I just summarize it as the bankruptcy court recognizes spendthrift trust. Let me see. Is there more on that? No. So there's a fraud exception from Wilcox. Not saying that this is just applicable in bankruptcy. I'm just looking at all of the citations here, which are almost done. Applies only to estate creditors, and restraints on P are valid. Applies to LE creditors and estate creditors. Okay, so there's a bunch of things that apply to different people in the citation section. Special language above boilerplate to overcome the threat of early termination that it doesn't have a material purpose. John Shipman Gray finds the spendthrift trust to be immoral and against public policy, but alternate view is that responsible lenders and creditors should be scrutinizing the interview of trust before holding interest in it as a security. Current law, all jurisdictions recognize the spendthrift trust as of 2004. Assignment before payment is revocable. Restatement section 58, debt binding on the Benny, not trustee, if assignment occurred before income and principal is due to the beneficiary. There is a jurisdictional restatement UTC division on assignments being binding when the principal interest is due but unpaid in the restatement section 58. Okay, so property that has become, this is a citation from it, property that has become distributable to the beneficiary but is retained by the trustee beyond the time reasonably necessary to make a distribution arising in right to demand in Benny is subject to an attachment. So I know that my beneficiary owes a creditor, and let's just say a self-settled trust where I'm the trustee and the settler, although that would probably not work, might not work. Let's just say I'm a trustee, not a settler, and I'm a trustee and I'm withholding principal and interest payments as directed for in the trust because I know that this creditor wants it. What this is saying is that they have a right to demand it if it's like immediately if distribution is a right. And under the Uniform Trust Code of Section 506, whether or not a trust contains a spendthrift provision, a creditor or assignee of a Benny may reach a mandatory distribution of income or principal, including a distribution on termination of the trust if the trustee has not made the distribution within a reasonable period of time. So you can't just be like, oh, I forgot to disperse the trust because you're trying to avoid the creditor's attachment or levy or whatever you're going to call it. All authorities agree after P&I is transferred to beneficiary that sums are transferable and attachable. And the jurisdictional differences are limits on amount that is inalienable, spendthrift provision requirement, education and support amounts are inalienable, and station and life test. That is interesting. The station and life test, I'm going to write that next to my makeshift definition of support trust. Because what they mean when they say education and support, one example is the station and life test. And this is to like justify giving rich people more money. Did I skip a page? So we're finally done with spendthrift trusts in general, but spendthrift exception creditors is the next section. Might be very much the same, but it is pointing to the Hurley versus Hurley case, where the bank ordered to garnish trust income, past and prospective, for child support judgment because that's what the settlor would have wanted. Probable imputed intent of settlor. The rule, Restatement Trust Second 57, in the absence of specific state statute, the income of a spendthrift trust for alimony, separate maintenance, or child support may be reached. And I guess I'm just citing that section of the restatement here exactly. Although a trust is a spendthrift trust or a trust for support, the interest of the benny can be reached in satisfaction of an enforceable claim against the benny by the wife or child of the benny for support or by the wife for alimony. That's A. B, for necessary services rendered to the benny or necessary supplies furnished to him, ambulatory medical personnel, hospital rights, not creditors, and for services rendered, and this is C, materials furnished which preserve or benefit the interest of the benny, and D, by the U.S. or estate to satisfy a claim against the beneficiary. See Uniform Trust Code Section 503 for government claimants as exception creditors. Spendthrift Trust Tort Exception. Tort claimants are exception creditors in Louisiana by legislation. Sly and Mississippi attempted to follow Louisiana without legislation and no precedent. And Mississippi legislator responded by contradictory legislation and thus created a claim nationwide, which gave the UTC pause to extend an exception for tort creditors in Section 503. And the Restatement Third of Trust, Section 59, Comment A, cites the circumstances of Sly. I love the Sly case. It's really offensive. Beneficiary displays pattern of tortious conduct. So he was like a drunk that would engage in DUI, driving under the influence, like often. So he's displaying pattern of tortious conduct, willful, fraudulent, and painstakingly reckless. And 2, policy grounds do not support immunity to protect the beneficiary of the trust and the behavior, and the conduct caused serious harm to others for which they could not have reasonably protected themselves, unlike a creditor who can. So they're going to overcome under those circumstances to attach or to be reimbursed by the trust, by this drunken beneficiary of a trust. So the first case is Schleffel versus Kruger, tort creditor resulting from a criminal act. Rule in the governing trust so proposes a benny of a trust shall not be able to transfer rights to future payments of P&I and a credit or interest in principal, and a credit of a beneficiary shall not be able to subject trust or beneficiary interest in trust to claim. Exceptions only if settlor is a beneficiary and assets were transferred to trust in fraud. And then the Sly versus tort creditor successfully takes trust corpus in Louisiana, but legislation changed throughout the country afterwards to try to allow for tort creditors to receive the beneficiary's interest in the trust when the benny displays a pattern of tortious conduct and it's not supported by policy grounds and it causes serious harm to others that they could not have prevented. Alienability. Next section. Creditors' rights to equitable interest in trust corpus, traditional approach, support trust, expectancy, ergo attachable, and discretionary trusts are merely expectancy interest, ergo not attachable. the Uniform Trust Code approach, a creditor may not compel a distribution that is subject to the trust's discretion, even if one, the discretion is expressed in the form of a standard of distribution and the trustee has abused the discretion. Only beneficiary can force the trustee to distribute to stand of discretion, not creditor. Standard of discretion, not the creditor. Restatement third approach, section 30, the beneficiary or creditor may compel discretionary distribution after a trustee is made aware of the debt, but always subject to court review of abuse of discretion, balancing creditor interests and beneficiary's interests. Trustee may favor beneficiary's interest by not paying as instructed under trust without liability for failure to perform. But sometimes the trustee, by not distributing, is actually found liable for failing to perform what their trust directs them to do. I don't have a citation for that yet. I'm only on page 13. Disabling restraint again. Term of a donative transfer in an interest in whole or in part constituted disabling restraint to alienation, aka disabling restraint. A disabling restraint imposed on a donative transfer on an interest in property is invalid if the restraint, if effective, would make it impossible for any period of time from the date of the donative transfer to transfer such interest. Forfeiture restraint, terms of a donative transfer of an interest in property which seek to terminate or to subject to termination that interest in whole or in part in the event of a later transfer constitutes a forfeiture of alienation. I'm just highlighting these, although I'm not saying I know what the difference is. These come from Restatement Second of Property, Section 4.1 and 4.2. It's really important, so I'm just going to read it one more time. A disabling restraint imposed on a donative transfer on an interest in property is invalid if the restraint, if effective, would make it impossible for any period of time from the date of the donative transfer to transfer such interest. A forfeiture restraint imposed on a donative transfer of an interest in property which seeks to terminate or to subject to termination that interest in whole or in part in the event of a later transfer. Okay. So example is that I'm given property, like with the condition that if I try to transfer it, it will forfeit my interest in the property, and like the transfer will be totally void. Kind of like reverts back to the grantor or their heirs and assigns, I think. So discretionary trust. A discretionary trust is a trust that contains a provision giving the trustee discretion to pay or to apply for the benefit of the beneficiary only so much of the principal and interest as the trustee sees fit. So that's your definition of discretionary trust, and that's really important to know. The case it's coming from is Marsman versus Noska. The lawyer is not professionally liable in the trustee capacity for failing to distribute when the life beneficiary was struggling, even when there was a curious relationship with the remainderman. There was an exculpatory provision for overreach or abuse, which is generally effective unless the burden of proof met showing breach of trust by facts at the time the exculpatory clauses was drafted. Settler's intent for exculpatory clause assumed by her competency. So, I wish I had the definition of an exculpatory provision, but I mean, clearly it's like trying to reduce the liability on the trustee. it's a settlers trust language to reduce trustee liability for using discretion. And the discretion is called for in the instrument, or it's a power granted by the instrument. So really, if you've gotten a discretionary trust, you should include a exculpatory provision. Otherwise, like anything that the trustee does can be looked at under scrutiny by the beneficiaries and potentially wind them up in court for a court interpretation of whether or not it was like within their power or reasonable or called for. Because there's going to be times when someone's station in life demands they have more money than they actually need for education and support, which, if you remember what types of support we're talking about, ambulatory medical personnel, hospital rights. I think I might just write that in the definition of support trust. Ambulatory medical personnel, hospital. Why? Because you sometimes have to talk about these things. I'm also going to call it discretionary trust, because how could anyone execute their powers under this without using discretion? So the range of discretion, I have a table here. I'm guessing the left side correlates to the right side. So range of discretion is given by the trust verbiage. The objective is support. Subjective is happiness. Vague, benefit. No, pure discretion. Court applies reasonableness. Extended. Oh, okay. So this table, range of discretion is on the left, and then the verbiage in the trust is on the right. So if the range of discretion is objective, subjective, vague, there's these are the different categories of the range of discretion. You could give extended discretion or extended discretion, or no, pure discretion. None is considered pure discretion, vague, subjective, and objective. So if it's objective discretion, the trust is going to say the trust's purpose is support. If the trust calls for happiness, like say for education, support, and happiness, then a subjective range of discretion, I guess, is the standard. And then for benefit, like education, support, happiness, benefit, that's referred to as vague. The court applies reasonableness if there's no standard for applying the discretion in the trust document. And if when it's extended discretion, the trust will say it's absolute or sole and uncontrolled. Those will be the words actually in the trust document. And restatement third of trust, section 50, discretionary power of a trustee to terminate the to determine the benefits to be paid to the beneficiary is subject to judicial control only to prevent misrepresentation or abuse of discretion Abuse of discretion, construction from settlor's purpose of granting discretion. Comment B, bad faith and proper motive to correct errors from mistakes of interpretation, unreasonable payments. Unreasonable payments inconsistent with trust provisions, clearly excessive, inadequate, failure to act. Discretionary and support are now treated the same per the restatement third of trust. Section 5860, hybrid, discretionary trust and support trust. Their new definition is discretionary support trust, aka discretionary trust with standards. Discretionary trust articulate no mandatory obligations, and support trusts the trustee to provide support for education, health, support, and maintenance of the beneficiary's lifestyle, etc. Discretionary powers. Exercise good faith and interest of beneficiary even when absolute. So I'm just going to point to page 15 for the definition of a support trust. Because it's perhaps a little bit shorter than what I wrote down. Incentive trust, discretionary support trusts. An incentive trust is a principal trust provides for trustees discretion by guiding rather than binding language. For example, incentive, graduation, abstinence, marriage within same faith, employment. Discretionary support trust from restatement third of trusts. Comment E, regarding consideration of beneficiaries' other resources in trustee distribution is required, is prohibited, is to consider the other resources, but have some discretion over the matter. An example, invasion of P for benefit over and above mandatory distribution before making additional payments regarding amount to distribute for discretionary payments from what trust period benefit is self-supporting. So what that means in English is like interpreted in the Wells versus Sanford case, asks whether the support trust should provide for incompetent beneficiary before she exhausts her own assets for support, and the answer is dependent on the interpretation of the intent of the testator in the instrument. In the case, the trust should provide for life beneficiary if she were to sell her assets to provide for her own support. That exceeds the intent ultimately for trust asset to reach remainderment. So that's like the first example, but the later example is like, or maybe the demonstrative examples in the book where like these beneficiaries make their own income and it's enough to support themselves without any distribution whatsoever. So if there's a support trust for their benefit, should it recognize that they're self-supporting, or should it just give them what any general individual would get for any under any like model support trust distribution, and not consider the fact that that person earns their own income? And it is relevant because there could be a life Benny in that case, and then remainderment, I guess, after the life Benny passes away. So the life Benny is self-supporting. Why would you give them distributions for their support? Because it's going to deter from the principal trust res that's available to the quote remainderment beneficiary in the trust. So support trust again, it's like so many pages. Let's get to page 25, just so we're halfway through. Support trust contains provisions directing the trustee to pay or apply only so much of the income, principal, or both for the support of the beneficiary as necessary for the beneficiary's education and support. This is just an example, I think, of more language that could be used. Trustee liability. A trustee is liable to the trust estate for losses from a breach or any profit that clearly would have accrued to the trust but for the breach, as well as any profit made by the trustee as a result of the breach. So I'm just going to write in the margin that is called surcharge. And fiduciary duty trustee. Trustee must exercise a duty of skill, duty, or care that would exercise to a person managing his own assets. So that's the degree of conservatism applied. And a settlor that forms a trust improperly cannot be found in breach to his beneficiaries. Instead, this will be viewed as an implied amendment to the trust within the power to himself to revoke, from the Farkas case. So if I didn't describe it, this section is the fiduciary duty of the trustee. And thus, that is like a go-to sentence, because a lot of these exam questions are asking, like, what's the duty of the trustee? A trustee must exercise that duty of skill, duty, or care that would exercise to a person managing his own assets, or care of that which would be exercised to a person exercised by a person managing his own assets. English. And a settlor that forms a trust improperly cannot be found to breach in breach. Okay, I said that. If that's the settlor trustee, like theirs are a little different. Legal responsibilities, more specific and onerous relation for corporate trustees than non-corporate trustees. And a fiduciary duty resolves a problem that trustees that own legal title have no stake in benefit for their administration because they are separated from the beneficiaries that own equitable title and lack control over asset losses. Fiduciary duties. Duties include duty to inform and account, duty of loyalty, duty of prudence, and duty of impartiality. Duty to perform an account, when to account, what to account. So this is on page 17. When is upfront, which is optional, periodically, which is optional, and final, which is required. What to account is a detailed description of the fiduciary's actions during the period, including property received, income earned, disbursements made, income and principal, taxes paid, and distributions of income and principal. Now, I'm going to first note that it's controversial how much information is enough for the beneficiary to effectively protect the interest, and may the settlor waive beneficiary's right to the information. The restatement allows the settlor to alter the right to information from restatement third of trust. Section 813 requires disclosure of an entire trust instrument to a bene upon demand, allowing only parts relating to qualified beneficiary to be disclosed. Under 7-303, only qualified bene need to be informed. Qualified bene is defined in section 203, and section 13. Required information is now only an option per bracketing in section 105. It's limited to like existence of the trust, the trustee's identity, and no right to request trustees' reports, and no right to accounting. So restatement, third of trust, section 82, comment A2, trust may limit the beneficiary's right to information reasonably necessary to prevent, information reasonably necessary to prevent or redress a breach of trust and enforce the rights of the trust. I feel like that's the minimum expectation. And if the trust contains no judicial accounting provision in the instrument to reduce the burden on the trustee, then the duty is to render periodic account to adult beneficiaries. Some jurisdictions are hostile to waiver of accounting. A case example of this is Jacob versus Davis. The trust instrument couldn't waive the remainderman's access to accounting because it is his only ability to redress and require in principles of equity, which is why I highlighted, restatement third of trust, that a trust may limit the beneficiary's right to information. I'm going to say except, which is like totally changing the language, but except for information necessary to provide and redress a breach of trust or enforce the rights under the trust. Because I'm just going to assume that I didn't understand that, because I read the case and I do understand that that's kind of like a minimum. So on page 18 now. Duty to earmark, duty of care, duty of impartiality, duty of loyalty, self-dealing. This is like the most important part of all of trusts. Just looking to see duty to invest and inform Prudent Investor Act. Oh, it's long. But if I could just get to the end of the duties that the trustee owes the beneficiaries, that would be good. So duty to earmark. Trust assets must be kept physically separate from the trustee's personal assets. In addition, trust property must be titled in the trustee as trustee. No commingling of one's own property or other trust property. If property is commingled or lost or destroyed, the property would be presumed to be the trustee's property, and trustee who commingles will be liable to beneficiaries. And the Uniform Trust Code, Section 810C, cites this as the distinct duty to earmark a trust investment so as to distinguish it from individual assets of the trustee is recognized by the authorities. Duty of care to act, duty of care of a reasonably prudent person managing their own property, which is like the exact same definition that I gave of fiduciary duty of trustee. Duty of impartiality, balancing duty to invest for immediate interest income and preserve principal for remaindermen. Benny remaindermen prefer capital appreciation. Benny life interest in income prefers income production. Beneficiary concurrent life, differing tax preferences between income and growth. And traditional rules come from the Uniform Prudent something Investors Act of 1930, which replaced the UPAIA of 1962, was replaced by that one. Answers how to allocate between principal and interest, and defines income as rent, interest, principal, payment of bond asset, principal, asset sales, capital gains, and dividends. And I give the citations here, but also the case on point is Dennis versus Real Estate Hospital Trust National Bank. The trustee mishandled real estate in the trust portfolio by exhausting its income ability to the benefit of the lifetime bennies and failing to improve it to continue earning income or to sell it before it lost too much value, and failure to diversify to the detriment of the remaindermen and grandchildren of the beneficiary. The court saw this as impartiality towards the lifetime beneficiaries, and there was a calculation given for the amount due the remaindermen, including inflation, which is very similar to a James case, which I don't have cited in here. But the calculation is being given, and this actually I've been asked for at least on 2 more occasions since writing it here in class. So the calculation is the value at the time it should have been sold. Like a prudent investor would have sold the property because it was losing its value, minus the value at the sale. And then times multiplied by the percentage of a return on ROR, if reinvested for a number of years. The return on interest. So you're going to multiply that difference that you lost in the value by the rate of return. If you had reinvested it at a percentage that would have been realized during that period, and the court removes the percentage for real appreciation to reduce surcharge on the trustee by, in this case, $20,000. So this case went on appeal because they thought that the calculation that the trial court applied was wrong. So this is where your duty of impartiality is most often seen. Was when it was kind of a failure to diversify to the detriment of the remainderman. There's probably a better definition out there. Some states allow equitable power to adjust between principal and interest. And then I give a bunch of citations like the Uniform Management of Institutional Funds Act, UMIFA, reform to UPMIFA in 2006, exercises total return approach, and the board to balance income and corpus operating needs. UPMIFA infuses and modern portfolio theory adopted everywhere but Pennsylvania, which I wrote down on purpose. Unproductive assets require sale per the Prudent Investor Act. So that's one thing to remember. Duty of loyalty, most fundamental duty of fiduciary to act. I put the charger over there. To act solely in the interest of the Benny. No self-dealing. A trustee cannot buy assets from the trust. No. Most fundamental duty of fiduciary is to act solely in the interest of the beneficiary. No self-dealing, and which we'll get to next. But the trustee cannot buy assets from or the trust or sell to the trust from his own property. He may not personally gain through his position. Undivided loyalty to the trust and equally among the beneficiary may not be tainted by the personal interest of the trustee. Undivided loyalty to the trust and equally among the beneficiary. I feel like that's actually the definition of duty of impartiality, right? But they're saying it through the lens of the duty of loyalty. Okay, so this I'm just going to write impartiality here. Because it's undivided loyalty to the trust and equally among the beneficiaries, and may not be tainted by personal interest of the trustee. Thus, a trustee must not deal with the trust and or his own capacity, for example, a bar or trust funds. A sure duty of loyalty is to require him to keep and render accountings. Self-dealing. Trustee sells trust property to itself individually or sells individual property to the trust. Per se voidable by no further inquiry rule. Right? No further inquiry rule is actually a rule. If the trustee has done something like this, like they're accountable. There's no further inquiry. Can't do it. Indirect self-dealing, for example, transaction to trustees, attorney, agent, entity of interest, such as a corporate trustee purchasing and or retaining its own stock, which is condemned for the possibility of conflict of interest. Voidable but not void can be subject to no further inquiry rule as well. So this would be indirect self-dealing. There's the estate of James. Trustee found responsible for negligent failure to diversify for inattention, inaction, lack of disclosure, but money damages, lost profits, market index replaced with the value of the capital that was lost, down $2 million. Lost capital is a more reasonable way to correct harm to the Benny. The calculation is the stock price on the date the stock should be sold minus the stock price at the sale plus interest plus dividends equals the damages not including attorney's fees. So all this is more ways of calculating quote surcharge. No further inquiry rule. By way of no further inquiry rule, without any proof of harm or reasonableness, self-dealing is punishable and all profit must be returned. Duty to invest, Uniform Prudent Investor Act. That's where the state of James came from, but I just jumped to it. Duty to preserve and protect the trust duty, and therefore the implied duty to make the property productive, example by invest, and continually review the investments. If he fails to invest, he is liable for what the trust would have made. Purpose, terms, distribution, terms, what did I just say? Distribution requirements and other circumstances due the trust evaluation to overall investment strategy rather than each investment. Shortly after appointment, the trustee must develop strategic strategy based on the purpose of the trust. Duty to diversify unless the trustee reasonably determines that the purpose of the trust is better served without diversification. Trustee may now delegate by prudently hiring an investment advisor. Restatement third of trust. Section 30, a trustee has no duty to perform personally except as a prudent person of competent skills might delegate to others those responsibilities. Comment J. Brings investment functions into scope if exercised reasonably with due care, not followed in UPIA Section 9 and UTC Section 807. Historically, the trustee performs discretionary acts and could not delegate authority for duties he can perform. Section from Uniform Trust Code, Section 808, allows the trustee to charge investment authority to a committee or advisor, but not full exoneration of the duty. My mind goes to the Barbary question that was like a double-edged sword. You're wrong if you're wrong, and you're wrong if you're right. Damage restatement, third of trust. Section 100. Damages include restoring value to what it would have been but for... Yeah, I think the Barbary question was like, can you... And you're supposed to answer this or that. Can you transfer investment authority to a committee or advisor, or... No, the question was, are you exonerated? Okay. Are you... It was like both of these options. It was like, you can either do this or do that. A trustee can either transfer authority to committee or advisor, which is true, but not be exonerated, which is also true. So you're supposed to pick which one of those. And I'm like, well, you're allowed to transfer. And they're like, no, you're still not exonerated. I'm like, okay. So hard. Like, I got every single one of these trust questions, like learning questions wrong. And it's like, well, I wrote 50 pages about it. So, like, what am I doing wrong here? Damages restatement third of trust. Damages include restoring value to what it would have been but for breach of duty. Calculate amount of loss. For example, value of investment trust instruct as instructed. Amount of loss equals the projected return minus the return received when underprice error is by comparable data minus punitive damages. So there's another calculation. There's like 4 calculations. Some of these essay questions, I'm like, and I make up my own. Avoid hindsight bias by ignoring subsequent increases in value. UPIA, the Uniform Prudent Investors Act. I have 5 notes about it. Scope prudence standard applies to total portfolio, all trust assets, not individual investments. Yeah, that was another question. So the other question was like, a investment is evaluated by the total portfolio, or the investment is evaluated by the individual investments. And I said individual investments. Yeah, but they were like, not. Like, but it says here the prudence standard applies to total portfolio, all trust assets, not individual investments. It's like, how do you do that? Like, bullshit. If you mess up on one investment, you're getting in trouble. Like, thank you, but no thanks. I subscribe to that. Mm-hmm. Keyword somewhere they do it this way. Trade-off between risk and return is identified as fiduciary control consideration. That's in the UPIA. All categoric restrictions on types of investments have been abrogated. Trustee can invest in anything playing an appropriate role in achieving risk and return objectives. Diversification integrated into definition of prudent investing, and delegation permitted with safeguards. And mine's like immediately went to like the west coast of Florida when I said trustee can invest in anything playing in all categoric restrictions on types of investments have been abrogated. Like, I just think about shopping for jewelry, like at like the tin city with my mom. Like, my mind is like, huh? What does that mean? I'm buying jewelry in Florida. Relates to other duties. Duty to loyalty, duty to account. Background and historic development. Restatement third of trust, topic 5, history, prudent man rule. Rule 1830, to observe how men of prudence... Oh, I wrote this down because it's so pretty. I might even tweet this. To observe how men of prudence, discretion, and intelligence... Gotta wait. I've learned about waiting. I know, this is my moment. To observe how men of prudence, discretion, and intelligence manage their own affairs, not in regard to speculation, but in regard to the permanent disposition of their funds, considering the probable income as well as probable safety of the capital to be invested. I thought that was so pretty. I was about to type that. And in a simplified version, the same Rule 15, 1959, is to make such investments as a prudent man would make of his own property, having in view the preservation ... So, who said this, by the way? It was, this is the historic prudent man rule from the Restatement Third of Trusts. Let's go ahead and tweet more stuff today. Speculation is imprudent per se. Modern portfolio theory challenges arbitrary restrictions arising from precedent as unwarranted and counterproductive. Right. So there's this new body of, or whatever, there's this new sweeping thought that all of these rules are too hard to comply with. And what they want is market risk is a risk, firm risk, non-market risk avoids justification, and high risk plus return trust instructions minus venture capital futures and options trading. So whatever that means is the modern portfolio theory. And statutory trustee earnings. Oh, this is the end of the duties. So that duty to invest is a doozy. But then I start all over again with what is a trust? I start all over from the beginning. Why? Because the class that I attended was wills and trusts. And I started writing this issue spotting outline during trust, which was the second half of the semester or the year. And so all of the things that follow from page oh my gosh. Okay, so I'm actually going to finish trust because right after I get to page 28 or so, yeah, once I get to page 29, everything from there on out looks like I started to write up my notes from wills, which was like the fall semester. So I'm going to divide there. I'm on page 22 right now, so it's only 7 pages. So I can get through that pretty quickly. The statutory trustee earnings. Trustee by statute may earn 1.5% of the trust corpus. And the family trustee, the trust provisions will apply to defer to statutes. So that's your statutory trustee earnings. Co-trustee, duty of active prudent participation to the trust and must act in unity. So if you're going to have 2 trustees, they both need to participate and they both need to act in unity. And then unanimity creates liability on all co-trustees for enablement of negligent inaction or improper delegation. So why you have to act in unity and participate is because if anything goes wrong, you are equally liable. One trustee may not transfer to the other the liability, and the second trustee will be equally liable as the first trustee who acted. Trustee acceptance. There's a presumed acceptance by an action or silence where a trustee is appointed. The trustee must clearly communicate a disclaim. Court supervision of a trust, atypical for an inter vivos trust. Section 201, inter vivos trust typically not subject to judicial involvement unless there is litigation between the trustee and the beneficiaries. Supervised testamentary trustee, whereas trustee of testamentary trust to take office or control after qualification by the court qualification can involve submission of the trust administration to continuing court supervision. Trustee to post a bond unless waived by the trust agreement. Qualification may require trustees are local. So this looks like a supervised testamentary trustee as a definition, and may be required to submit periodic account and final accounting. Trustees are sometimes duly appointed to minors as guardian ad litem. And UPC, the Uniform Probate Code, talks about this, but the Uniform Trust Code replaced the Uniform Probate Code, but the PUC, Uniform Probate Code, is still operative in some states and makes trusts have passive jurisdictional relationship with the court. Latches, so trust liability defense. This is actually really important. And it looks like most of it is being demonstrated by Marsman versus NASCA for exculpatory clauses. And then National Academy of Sciences versus Cambridge. I remember that case. That's the case that gives us the constructive or technical fraud statute, standard of constructive fraud. And then there's also a matter of Green Charitable Trust, a trustee who was a lawyer where the trust was administered and worked for the bank where the trust was maintained, arranged for the private sale of the trust assets to his own client after the death of the life tenant and didn't properly market the land to get the best price. So this is it's not like self-dealing, but it's definitely a breach of the duty of loyalty. So going backwards a second to the National Academy of Sciences, like what ultimately happened was the trustee was liable to the remaindermen who were able to reopen settled accounts when they learned that the life Benny was 22 years and eligible for continued benefits because the trust only provided for her until she got remarried. Like her ex-husband or whatever, her predeceased husband was providing for her by trust until she got remarried. So and then the remainder was supposed to go to the National Academy of Sciences, but she was like, the trustee was not following up on her marriage status, and so she just kept endorsing the checks that were coming, and the trustee was held to a standard that he knew or should have known, even if she lied on like annual declarations about not remarrying. And the constructive or technical fraud statute doctrine from a Rasmussen case reads, where the subject matter is one of fact in respect to which a person can have precise and accurate knowledge, and he speaks as of his own knowledge and has no such knowledge, his affirmation is essentially false, which is speaking to the surviving spouse's annual declarations. So for the code, the standard of constructive fraud at leave to extent that fiduciary has made no reasonable effort to ascertain the true state of the facts it has misrepresented in the accounts, not strict liability standard, nor does it make a trustee an insurer against the active fraud of all parties dealing with the trust. So you don't necessarily need to look up a fact of independent significance. You don't necessarily need to validate that your annual declarations are true. Laches is another defense. Exculpatory, which is a delay by the beneficiaries to contest or object to an accounting in that example, but it's just to the prejudice of the defendant party, is the more commonly used basic definition. Exculpatory clauses immunize the trustee. It is contained in the trust instrument, but doesn't apply to bad faith breach of total claims. Did you see him snatch some food? Did you see him do that? Yes. Exculpatory clause is not permitted to immunize trustees of bad faith, reckless indifference, intentional neglect, or willful neglect. Unenforceable to the extent that it relieves the trustee of liability for breach of trust committed in bad faith or with reckless indifference, or was inserted as a result of an abuse by the trustee or fiduciary confidential relationship to the settlor. As it relates to beneficiary creditors, if Benny can assign then trustee liable to credit for paying Benny before creditor pursuant to assignment, see Hamilton versus Drogo, New York, following New York civil practice law, up to 10% spendthrift trust income, now codified into Section 303 of the California Probate Code, that the trustee is liable to the creditor for impairment of creditor's rights. So, note. Interestingly, is that we don't actually have to answer the questions according to California code, like in the area of trust, but we are in the area of wills. I'm on page 24 now. I actually almost have 5 pages. Personal liability. Creditors' claims against the trust can be paid by a trustee personally or trust assets. Trustee personally liable for contract it enters on behalf of trust in fiduciary role and may be indemnified by trust assets if contract is within the trustee powers. There being an indemnity, then creditor brings action against the trust. There being no indemnity, then creditor brings action against the trustee. Indemnity is legal fiction for substituting the trust for the trustee. So that's personal liability, probably of the trustee, and a little bit about indemnity. I'm guessing is how trustee. Okay, so the trustee is going to enter into contracts on behalf of the trust, and they're going to be personally liable for those. But it's also saying it's dependent on whether or not there's an indemnity clause. Matter of Lathers, New York, 1930. Johnson versus Long, California, 1947. City of Phoenix versus Garbage Service Company. When I wrote this one down, oh, it's not that long. When VNB, a trustee, owned land where the defendant managed the site until it was closed in 1972. And the trustee got busted with Comprehensive Environmental Response Compensation and Liability Act, CERLA, amended in 1996. Where they were like, we don't care if you have exculpatory clause. You didn't keep this land clean. You're liable, and for lots of money. So that's why I wrote it down. Unjust enrichment recognized. If there is an unjust enrichment when the trustee personally responsible, or vice versa if there is a lack of benefit and or fault on the part of the trustee. SOR law creates personal liability for a fiduciary of trust assets that are creating hazardous waste. Breach of fiduciary duties. Right to ratify a breach of fiduciary duty is held by Settler Benny of the trustee's breach of trust if Benny consented to the conduct constituting the breach unless the consent, release, or ratification of the Benny was induced by improper conduct of the trustee, or at the time of the consent to the Benny did not know of if the Benny's rights or if the material facts relating to the breach, and the court may also authorize a breach of trust. So this is what we talked about in class, like a lot. So the word consent is used, ratification, release. Those are all 75-cent words. Trustee resignation. Trustee must resign if he doesn't want to continue in that role, if with court permission or in any way that is authorized by trust terms or all beneficiaries' consent. Devolution of a trustee title upon death by statute. See New York Successor Trustee Solution. Compensation of trustee. Fiducial compensation practices as stipulated in the trust instruments, and if reasonable compensation is applied to trust in Uniform Trust Code Section 708 default rule on standard of reasonable compensation. If the trust instrument specified the compensation level, the court may allow more or less in either two circumstances. And this is your default rule. The trustee duties are substantially different from those initially contemplated, or the specified compensation is unreasonably high or low. But as you know, the statutory rate was like 1.5% of what is actually a good question. I know it was like trust corpus. They may earn that much, but it doesn't say like how often, like annually or monthly, or probably not. So moving on, the trustee duties. Okay, so if the court applies compensation that is later rendered unreasonable because the trustee's duties are substantially different from those initially contemplated, or the specified compensation is unreasonably high or low, then I'm guessing it can be adjusted. Removal of a trustee. A court must remove a trustee either at the request of the beneficiary, co-trustee, or the settler, or on its own motion, only under 4 limited circumstances: serious breach of trust, 1, 2, lack of cooperation among trustees substantially impairs trust administration, 3, removal would serve the best interests of the beneficiary because trustee unable or unwilling to administer trust effectively, and 4th, because of the substantial change of circumstances or upon request of all beneficiaries. Under Part 4, it says the court finds that removal best serves the interests of all beneficiaries and is not inconsistent with the material purpose of the trust. To further define what is meant by 4, a substantial change of circumstances upon the request of all the bennies. Trusts, then I define once again on page 26, and I then go into what is certainty of subject, certainty of object, and certainty of intent. I went through all of this in the beginning, but I'm going to say it again because it's important. Historically, trusts arose from the statute of uses, subject to RAP, the rule against perpetuity, so that a trust must terminate after 21 years of last living beneficiary. The key words to know is settler, grantor, trustee, beneficiary. Enforcement, dual enforcement, legal and equity remedies are available. Contract treatment has limited applicability. The components of a valid trust is the present transfer, certainty of object, subject, and intent. So present transfer is even if future interest, equitable life estate, equitable remainder. Okay, what that actually means is that the settlor has to transfer property to the trust. Legal title. Certainty of subject, specific trust property or res, certainty of object, identifiable beneficiaries, and certainty of intent is a specific intent to create a trust. Types, irrevocable and revocable trusts emerge and are widely marketed. Types of revocable trust listed in the business include express trust for charitable purposes, blind trust prevents a conflict of interest, self-declared, self-managed, probably called self-settled. Successive generations, skip generational inheritance tasks, standby, guardian by durable power of attorney, bypass, marital deduction to benefit from tax breaks. And those are the types of trusts that I wrote down here. Certainty of subject. This is defined by the Brainerd versus Commissioner case that trust tax treatment and trust fail because only legal property that is transferable can be property of trust, which accepts necessarily expectation interests. Yeah, because this guy just like set up a trust, but he didn't put anything in it. So yeah, it's going to be liable for IRS debts. I think that's how that went. I remember reading that case at Perkins with my mom. That's why I like studying different places because I really remember the stuff. Like that case about the natural sciences or whatever. I was at the pool. I guess it was the pool. Oh yeah, and that's the day that Joyce started talking to me. I think. And then trust requires subject res, owned interest rights, or equitable title portions transferred to or further subdivided among beneficiaries. See Matter Brown 1930s statute of fraud treatment of real property. Afterward, the restatement third of property section 6.1 comment O clarified writing. Trust tax treatment and trust fail because only legal property that is transferable can be property of a trust which accepts necessarily expectation interest. You can't just say like, I'm creating a trust to hold like money I get tomorrow. Certainty of object, identifiable beneficiaries. The property may be titled in the name of trust by quitclaim deed or title fragmented, legal and equitable title separation. Restatement third of trust. Trust treatment of friends is indefinite. Comments help consider friends relatives so that they do not fail for indefiniteness unless there is only one and cannot select among them. UPC, Uniform Probate Code, Section 2-711, donation, disposition to relatives or family will treat as legal heirs. So these are matters of construction when the trust instrument is unclear in its identification of beneficiaries. Rule, requirement for definite class. Where a fiduciary is under duty to select the beneficiaries of a trust among a class, the entire membership of the class must be definite and ascertainable. Honorary, non-charitable trusts, trusts subject to the rules against perpetuities. Scott, Section 123. 1 requires power of appointment by trustee. Restatement third of trust, adopt a trust, grants trustee power to distribute or apply property. 21-year year not a hard requirement, i.e. grave maintenance for life of immediate family. The cases on point are Hayes versus Rager. Equitable owner can defend title from creditor judgment and invalidate a previously held share of sale. Mooresman versus Commissioner, trust tax treatment and trust fail because of lack of beneficiaries. Unmarried man has neither a widow nor an issue. Clark versus Campbell for default treatment of friends as relatives. Estate of Searight, pet as trust Benny is permitted. The value of the pet itself is taxable. Certainty of intent, specific intent to a trust. It's so funny. I was trying to calculate how much Bubba was worth. You'd be taxed if he's worth a lot. Except that you're his biological father, so I guess it doesn't matter. I guess you can't be taxed for your issue. Yeah, my mom and I went over the definition of issue, too. I think in the Perkins Diner, we're talking about how children are issues. Your child is an issue. It's like termed properly. Okay, on the second to last page. I'm on the last page. Certainty of intent Specific intent to create a trust. Intention to create. A trust is created only if the settlor properly manifests an intention to create a trust relationship. That's like your definition, according to Section 13 of probably I don't even know if it's a restatement of trust or if it's a uniform trust code, Section 401. Notice and acceptance by any trustee not required to create a trust. Restatement third, Section 6.1. This is third of property, actually. A writing is not required. Restatement third, restitution and unjust enrichment. When death thwarts trust formalities to be effectuated, the trust intent of someone who dies or becomes incompetent before the transfer is completed may be given effect by a constructive trust in order to prevent unjust enrichment of the property owner's successors and interests. In California and Texas, consideration is not required to create a trust, but a promise to create a trust in the future is enforceable only if the requirements for an enforceable contract are satisfied. Precatory language, restatement of trust, section 13, comment D, unless the testator or other transferor manifests an intention to impose enforceable duties on the trustee, the intention to create a trust is lacking and no trust is created. Factors include 1, brief, because eminence of death. 2, request seated in circumstances that show intent. Settlor maintain the money, beneficiary support during his lifetime, etc. And I wrote like a million. I wrote a placeholder to put all the factors in. And the case is Colton versus Colton. That was the case I was trying to find earlier. A trust is created if the duty to transfer is not definite, but recommendation and request. Like, this trust is to benefit my wife with the wish or hope or anticipation that she supports my mother. And so this was like a case in California way back, and the recommendation request arises into a trustee duty when the circumstance on the wife to support the mom, when such would be given effect and given in brief, but it was only briefly written out because the husband was about to die and upon the settlor at the time of the creation. Also, it was important factually that the husband had sent support for his wife or for his mother and sister throughout his life. So they were able to use these factors to interpret that Colton wanted his wife to, like, even though it was his wish, it was actually, his intent that his wife support his mom. Farmers Loan and Trust versus Winthrop, New York, 1924. Series of check to be deposited into trust with letter of instructions was affirmed as an inchoate gift. The court couldn't view the several documents as part of a single plan in order to be given effect to a trust for daughter and son's children as deigned by acts of depositing checks or otherwise. So I'm pretty sure in this case, like, these checks they're talking about are like over $1 million, and this chick is going into the bank and depositing them in a trust account, but she didn't really finish the thought or something like that. The checks didn't clear yet or something, and so ultimately those people didn't. They're trying to say that money was supposed to be held by that bank and trust for them, but they, I don't know, probably just went to her estate and probably just got distributed by her will or intestate succession or something like that. That's it for trusts. The following, then there'll be 20 pages on wills in a later recording.